Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to try to give you some perspective for understanding your termination letter and the termination and severance pay package that's contained therein and what the purpose of the letter is. And the key that we're looking at is an understanding is the fact that this is written from the perspective of the employer, designed to protect the employer, and written only to state those things that the employer wants to say. It's not trying to give information that's necessarily beneficial to the employee that would be counterproductive to the employer. Sometimes it is contained therein, but for the most part, it only is intended to contain information that the employer needs to communicate and wants to communicate. And as such, it's going to abstain from communicating information that is not necessarily negative or harmful to the employer. So another aspect is that it has the pretense of legal compliance from the most favorable position to the lawyer. And what do I mean by this? What I'm talking about is if there's a range of positions from a legal perspective where something can stand on, it's going to take the most favorable position to the employer. So if something could be said to be valued at $20,000 versus $10,000, and there's an argument that can be made at law with great substance for $10,000 being paid out to the employee, that is what's going to be presented in the letter. They're not going to present the most favorable employee position. They're going to try to present the most favorable employer position that they're able to get away with and that they're legally able to substantiate. Because when they're presenting these documents and presenting legal paperwork, they're hoping that this is satisfactory for convincing the employee who's under a lot of stress and pressure and doesn't regularly see his paperwork, that they will accept this blindly on faith, that it's so heavily entrenched in legal language and complexities that they won't really question what's being asked of them. And even if there is a demand for something more, what's going to be offered is just a pittance, in the sense that if technically you could be asking for $20,000, they're offering $10,000, and you ask for something more, you might get another $2,000. That's really what it comes down to. There's sufficient legal basis for the position they're putting forth, and that's what they're offering up. And that's a matter of economics and rationalization that's done on the part of the employers. Furthermore, the letter is not intended to give clues as to discrepancies, issues that might arise either with the termination severance pay package or with one's prior employment, or with respect to issues that could adversely impact the employer. Although it seems to cover a lot of materials, when it comes to those aspects that could be adverse to the employer, it very much is a minimalist document. It tries to say as little as possible because the less, the better for the employer. From the perspective of the employee would want a whole story, a whole full body explanation as to why they're no longer having a job. But that's what employers are told to refrain from doing. Simply given the very basic skeleton, which does not implicate the employer in any way, or that can be manipulated and subterfuged to provide a different answer. Instead, it is premised on the belief that all calculations and payments are correct. It presents a methodology, or it doesn't really set out the methodology, but it says this is in line with the applicable statute, and that's the end of it. And when you see that, you might well think that could be correct. The problem is, unless you're purely based on a simplistic contractual arrangement, when you're actually subject to employment standards legislation and the methodologies for calculating stuff are subject to statute, and especially where the statutes have complexities in them, it's never a simple thing. There's considerable variances that are possible. And if anything, the employer is taking a minimalist approach as always to stuff because it's to their advantage. Because you also have to remember, when you're leaving a job and you're getting terminated for whatever reason, the employer is paying you out but is not getting any further benefit from this, in the sense of they're not getting further labor or input from yourself. This is simply either a requirement of contract and or a requirement of statute that the individual now has to be paid out as they exit the door. And because of that, it is incumbent upon yourself to not simply think that the calculations are simplistic and straightforward, especially where there's complexity involved in your calculations. You can see this oftentimes for payroll statements, but pay statements are problematic of themselves. Now, another problem is that oftentimes you'll see one or two figures, numbers, that are listed in the termination letter, which is the basis upon which your termination and severance pay package is set out. But what is happening is, by combining payments into single numbers that attempt to limit the employee's ability to properly perform calculations, you're going to have a hard time of understanding whether or not those calculations are correct. And it's not as easy as you might think. There's methodologies and procedures that a lot of employers use to create some type of number that has some type of basis upon it. But all too often what I see is those calculations, unless they're substantively higher than anticipated, are in fact egregiously low, and they miscalculate, especially when it comes to the application of statute, where statute is the controlling factor. Common law, naturally, with respect to severance pay, is a different beast of itself. But then the question becomes, how much of the statutory aspects have been complied with? Because to deal with the common law and to deal with severance pay effectively, oftentimes you need to have leverage. It's not an absolute, but it gives you a far stronger position to proceed, at least from a legal perspective. So when it comes to severance pay calculations, employers tend to be elusive as providing the calculation methodology. They lump everything together. They say, this is what we're going to provide you with. This is what we somewhat base it upon. But it's one large number, throws in a lot of other components. And unless you know how to break it down specific to the jurisdiction within which you are working in, it's very difficult to discern. And at the same time, employers are very reluctant to provide the basis upon which they have determined the number. They don't want to, because then it gets into complexities and creates problems for them. And once again, less is more from the employer's perspective. Also of considerable significance is what is missing from the termination letter and the underlying severance package that is being provided to the individual. There might seem like a lot of materials there, a lot of aspects that we'll be covering, but it is somewhat deceptive as much as written to protect the employer. If you don't know what you're looking for, you don't know what you're reading fully, because you're probably reading it for the first time or first time in several years, you're not going to necessarily discern what else should be addressed. You can almost go through these and say, this is appropriately covered, but at the same time, let's say, we first say, what mark out with yellow highlighter, what is written from the perspective of protecting the employer but then more so afterwards. What is missing? What is absent? And one of the pieces of information that is very important to this and shows you what's absent in many respects from the termination letter is the legal release that is oftentimes accompanying the termination letter. Because what you'll see oftentimes is there are aspects in the release that are not even addressed in the termination letter. So they're saying we're addressing this, and we're addressing this in the termination letter. But meanwhile, there's a couple other things, especially with respect to past employment situations. And those are completely closed off once you accept the payout. So an employer would not just say, well, that's because the lawyers tell us we've got to cover every aspect. We don't want to come back after us. And if they didn't know better, that might be true. And oftentimes they don't know better about stuff. But the fact of the matter is, all too often what we're seeing, at least here in Alberta, is that there are aspects within that package that are necessarily not being addressed, and there's no desire to address them. The only aspect that they want to do is close it out, shut it down, and be done with it. Now, also, you got to remember that these termination letters, which set out the termination severance pay package and the accompanying releases and all the other documentation, has been carefully drafted by lawyers to limit the exposure of employers. They are very much formulaic, and the templates have become so generic that they are all too often developed for one jurisdiction, specific employment laws, and are used in an incompatible jurisdiction with key legal differences. Now, this is a very serious point to remember. The fact of the matter is, there are differences between jurisdictions, whether at the federal level and then the state and provincial level, or between the states or between the provinces. And these distinctions are significant. Yet all too often what's happened is that employment matters, especially where they're based on statute heavily, as in Canada, has found that termination letters tend to be generic. And the ones that come out of Ontario tend to be used in all provinces and even at the federal level. And this is an issue because there are substantive differences. And unless your lawyer knows this, and unless you know this and understand it, you don't pick up these subtle differences. And the subtle differences show you that they're not really keyed in to what really needs to be going on. And when I talk about being keyed in on what's going on, I'm not just talking about your termination of severance pay, but I'm also talking about back pay and other aspects of calculation, which can be extremely problematic for an employer and advantageous to yourself. But you got to know how this is coming out. You know how to read it, and you know how to pick it up. That means you need to get the right lawyer oftentimes to understand that, to gauge it, and to sense where the discrepancies are. Because as soon as you start picking up on those discrepancies, you are keyed in to where the issues are. There's other ways that we target and identify where there's high probability of issues and discrepancies. But that's one of the major ones. Now, here is another issue for employers and what they're trying to avoid. And that is the problem that correcting errors in termination pay calculations could shed light on other prior errors that relate to prior pay, since this typically is all tied together, especially where it's heavily dependent on employment standards legislation, as in Canada, and the use of similar calculation methodologies. Termination pay is but one methodology for calculating stuff. Depending upon how termination pay is calculated, this has a lot of impact on how severance pay is calculated, how overtime pay is calculated, how vacation pay is calculated, how statutory holiday pay is calculated. And there are differences, especially between the provinces, as to how these payment calculations are done. But all too often what we see happening is that there's a uniform or a default approach. And the default approach is one approach that seems to be used throughout North America, apparently, even though there are distinctions within North America, and especially distinctions up here in Canada, which create issues. And the first issue that's created is with respect to termination pay in lieu of notice. But you then go back and you discern this right away. There is a possibility to discern other back pay issues. And this is very serious. And the fact of the matter is, employers are being very careful about this. In some respects, they try to keep their systems correct because the errors tend not to be limited to a single employee, but all employees working for that particular employer, meaning that there is a serious financial cost to the employer should this be identified. This is a particular concern for employers, and employers don't fully recognize this or appreciate this. Because when you identify issues, you identify problems, you really can put the employer on the hook. Now, to sum it up, what I have to say is, yes, there might be nothing there. Your employer might very well be making all the calculations, all the payments appropriately and correctly to yourself, both prior to your termination and at the time of your termination with the termination severance pay packages available. That's entirely possible. And depending on where you're working, that's entirely within the line. But if there is something, do you really want to forego what you are legally entitled to since you earned it? And we're talking about money that you deserve. The law says you are entitled to, your contract says you're entitled to, employment standards legislation says you're entitled to, because you did the work, or it's tied to the work that you have done, especially when we're talking about potentially tens of thousands of dollars, and even in excess of $100,000. Should you, in fact, be letting this simply slide because you cannot fully grasp and understand the termination letter that's been put in front of you, the termination and severance pay package that is contained therein, and the underlying issues that need to be reviewed, the other materials that need to be scrutinized and assessed? Because you got to remember, statute, and more particular employment standards legislation, was created and designed to protect the employee. And the employer, all too often, unfortunately, is not observing the employment standards legislation that is governing the employment in their particular jurisdiction. And this emanates from a number of reasons. One of them is this universal common payroll software that tends to be used. Another tends to be the training of payroll staff. And finally, what I've observed, what I believe is a major problem, is the fact that employers don't want to engage lawyers to review their payroll systems. They have some review of termination and severance pay packages, but that's not the end of it. They don't want them to review their overall payroll, nor do they want them to take the lawyers actively scrutinize and want to work on these aspects of mathematical calculations and computations and methodology, which is not really their forte. And for what purpose? To try to tell employers that there's a possibly higher amount that's due to employees when employers already feel that they're overpaying their employees. First of all, they don't make sense of it. They don't try to make sense of it. And their job is not to necessarily help the employer find out how they're underpaying their employees. That's not necessarily the job of employment lawyers who work for the big companies. Instead, all too often, first of all, they don't fully grasp what the law is. They don't spend time working with the law, otherwise they make the most obvious and clear corrections in far too much stuff. But instead, what is happening is they are focused on the higher, larger transactional matters, and they don't work on the payroll side, and they don't even work heavily on the termination side. And what they definitely don't do is they don't go and say, how am I going to go about and potentially clean up my client's mess, being the employer, and address what could be potential oversights and underpayments. That's not what they do. That's not what they're tasked to do. What they're tasked to do is to simply provide, if they're even involved in it, a formulaic approach that gets the employer away with the lowest possible amount paid and limitations on legal exposure. And that is what a termination letter does. And it doesn't try to position the employee so it can challenge the employer. And once you realize that, and once you understand that, you understand the importance of engaging knowledgeable legal counsel to properly assess your termination letter and the termination severance pay packages being offered and the overall remuneration that you come out of this job. Because once you sign off on that paperwork, you're very much done, with some exceptions. And that is why it's always strongly recommended to at least take a look at it with a lawyer who is knowledgeable in the area. And they can very quickly discern, if they know what they're doing, whether or not there is some possibility for substantial underpayments and what the degree of challenge is in pursuing that matter. Thank you.